Good morning, guys. Today we are going to distinguish certain contracts from sale. Alright, now let's distinguish first sale versus Dacion in Pago. Then we will distinguish sale versus payment by cession. Then we will distinguish sale versus barter, sale versus contract to sell, and sale versus contract for a piece of work. So let's discuss sale versus Dacion in Pago. Well, the distinction are sale creates an obligation while Dacion in Pago extinguishes an obligation. In sale, the cost or consideration is the price, while in Dacion in Pago, the cost or consideration is the extinguishment of the obligation. In sale, there is pre-existing contractual obligation. There is no pre-existing contractual obligation, but in Dacion in Pago, there is pre-existing contractual obligations. Right, now, let's go back to our law on obligations and contracts when we talk about Dacion in Pago. Well, Dacion in Pago is a special mode of payment, and payment is one of the modes of extinguishing the obligation. So, Dacion in payment or Dacion in Pago is a special form of payment where the ownership of property is transferred to his creditor to pay the debt in money. So let's say, for example, if you owe me 15,000 pesos and by the time the debt is due, you said, "Sir, I don't have enough cash, but I am willing to give up Samsung S7 Edge Plus for the payment of the obligation." So in this case, giving up the Samsung S7 Edge Plus will constitute full satisfaction of the obligation. Well, you need to take note that in Dacion in Pago, the debtor need not be insolvent. Alright? And the debtor need not abandon or assign all of his properties in favor of the creditors. Well, in Dacion in Pago, it may be in favor only of one creditor or two creditors, but not all. So let's go back to the situation. You give up your Samsung S7 Edge Plus for the payment of the obligation. Once you deliver Samsung A7 Plus to me, and I agree to that it will constitute as a form of payment for your obligation, then delivery transfers ownership. Okay? In that case, but well, it will extinguish the obligation. So that is why the Dacion in payment will not create obligation, but instead it will extinguish the obligation. Is it necessary that the debtor in this case is insolvent? The answer is no. Okay, so what if, for example, I sell Samsung S7 Edge Plus. You owe me 15,000 pesos. Then you give me Samsung S7 Edge Plus. Subsequently, because I badly needed the money, I sell the Samsung S7 Edge Plus. And it was sold only for a price of 12,000. Can I run after you to ask for the deficiency? The answer is no, because once you give up Samsung S7 Edge Plus, that constitute already a full, or that will give an effect of full satisfaction of the obligation. So I can no longer run after you to ask for the deficiency since you owe me 15 and it was sold only for 12. I cannot run after you to ask for the deficiency or to pay for the deficiency of 3,000. Let's go back to the situation. What if I was able to sell it for 17,000? Can you as the debtor run after me and collect for the excess since there was an excess? The answer is no. Why? In the Dacion in Pago, once you give up the thing, that already constitutes full satisfaction of the obligation. Once you give up the thing and delivered it to the creditor, that the ownership of the thing is already transferred to the creditor. So because it was sold more than what you are obliged, doesn't mean you are entitled to the excess. Ownership is already transferred, and so therefore any gains out of it will be due to the creditor. All right. Now let's go to the distinction between sale and payment by cession. Well, same with that of the distinction of sale versus Dacion in Pago. In sale versus payment by cession, sale creates obligation, while payment by cession extinguishes the obligation. Sale, the cost or consideration in sale is the price, while the cost or consideration also in the payment by cession is the extinguishment of the obligation. In sale, there is no pre-existing contractual obligation, while in payment by cession, there is existing contractual obligation. In sale, delivery transfers ownership, but in payment by cession, delivery will not transfer ownership. Now, same with that of Dacion in Pago, payment by cession is also a special mode or a special form of payment. Since it is a special form of payment that under the law on obligations and contracts, payment is a mode of extinguishing the obligation. So that is why Dacion in Pago and payment by cession all is for the purpose of extinguishing the obligation. What is the situation in payment by cession? The debtor in this case is insolvent. When we mean insolvent, it simply means the assets of the debtor are not enough to pay all of his liabilities. So the assets are not enough to pay all the creditors. So what happens in payment by cession is that debtor will give up all his assets or abandon his assets or assign his assets in favor of the creditor. Now, the creditor will then sell the assets of the debtor and apply the proceeds to their respective receivables or claims. Now, since the debtor abandons the property or assigns the property to the creditor, does it create transfer of ownership? The answer is no. What the debtor did is just to assign it to the creditor and without transferring ownership. Will it constitute full satisfaction of the obligation? The answer is no. Alright, because the act of abandoning or the act of assignment of the debtor to the creditor is for the purpose of the creditor selling the property, not for the purpose of full satisfaction of the obligation or transfer of ownership. So, in payment by cession, if the proceeds of the sale of the assets of the debtor are not enough to apply or to pay the liabilities or claims of the creditor, then when there is a deficiency, the creditor can run after the debtor for the deficiency. What if there is an excess? But I doubt if there is an excess in a real life situation, because in this case, the assets of the debtor are not enough to pay the liabilities due to the creditor. So, you will not expect that there is an excess, but nevertheless, the law provides that if there is an excess, okay, the creditor is now selling the assets of the debtor. Now, the proceeds of the sale is more than that of what is due to the creditors. Then is the debtor entitled for the excess? The answer is yes, because the act of abandonment or the act of assignment does not transfer ownership to the creditor. So, if there is an excess, the one that is entitled to the excess is the debtor. Alright. Now, let's go to sale versus contract for a piece of work. When we talk about sale versus contract for a piece of work, when you produce goods for the general market, then it is sale. But when you produce goods only tailored fit for or designed for purposes of a special person, then that is considered to be a contract for a piece of work. Let's say, for example, Okay, let's say for example, you are about to be wed. So you need a gown. So if you go to the department store and look for gowns available in the department store and choose one of those wedding gowns, then it is a contract of sale. Well, wedding gowns are there. It was made for general public. So it is considered to be a contract of sale. But let us say, for example, if you're about to be wed and you don't want to buy a generic wedding gown that is available in the market, you want it to be special, you designed your own gown. So you go to the tailoring shop and ask the tailor whether he can make it. Okay? So a special design for you. Then the tailor said, well, I can make it. Then the contract that is entered into is a contract for a piece of work. Alright, let's go to sale versus barter. Well, let's say for example, I need a coconut land. You need a car. I have a car. You don't have a car. Okay, so you want my car, and I want your coconut land. So we exchange. Is it a barter or a sale? Well, technically, if you take a look at the situation, it's considered to be a barter, a thing for a thing, right? The problem will arise when, let's say for example, the arrangement is, you give me your coconut land, I give up my car, plus 100,000 pesos cash. Okay, so is it a barter, a sale, or a barter? So the question now is whether it's a sale or a barter, since there is a non-cash consideration and a cash consideration involved. Now, the law said, well, the first thing that you will take into consideration is the intention of the parties, whether the party intended it to be sale or whether the party intended it to be a barter. Okay, so when the party's intention is sale, then it is a contract of sale. But if the intention of the parties is that it is a barter, then it is considered to be a barter. However, if the intention of the parties is not clear, you cannot see it or infer from their intention or from their agreement that whether it's sale or barter, then the law provides for the rule. It is considered to be a barter if the value of the thing is more than that of the money. Okay. If the value of the thing given up is more than that of the cash consideration. If it is a sale, if the money given up is more than that of the value of the thing. So let's say for example, you give up your coconut land, which is a fair market value of 500,000, in exchange of my car, which has a fair value of, let's say for example, 400,000 plus cash of 100,000. So, is it a barter or a sale? It's considered to be a sale when the parties intended it to be sale. It's considered to be a barter when the parties' intention is to make it is that it is a barter. But if the intention of the parties are not clear, you take note, your coconut land is 500,000. My car's fair market value is 400, plus I will give you 100,000 cash. Since the car's value is 400 and the cash consideration is 100, then the law said it is considered to be a barter because the cash consideration is less than that of the non-cash consideration. Okay, let's go to sale versus contract to sell. Well, in sale, delivery transfers ownership, but in the contract to sell, it's not delivery that transfers ownership, but it's the payment, full payment of the price. In sale, the buyer bears the risk of loss due to fortuitous event after delivery, because you need to take note, in sale, delivery transfers ownership. And we follow the rule on res perit domino, or owner bears, or the thing perishes with the owner, So since it is already delivered, the buyer is now the owner. And so therefore, when it is lost due to fortuitous event, then the buyer should bear the rest of loss in the contract of sale. But in the contract to sell, you need to take note that full payment of the price is the thing that will transfer ownership. It's not delivery. So when the thing is delivered and the thing is lost due to fortuitous events in the possession of the buyer, it's not the buyer that will bear the loss, right? Because the buyer, though it is delivered, though it is in his possession, in the contract to sell, delivery does not transfer ownership. So if you follow the principle of res periet domino, right? The thing perishes with the owner, though it is in the possession of the buyer. But because in the contract to sell, delivery does not transfer ownership, then technically the owner is still the seller. And so therefore, it must be the seller that bears the rest of loss. Okay? So, let's go to sale versus agency to sell. Well, in sale, delivery transfers ownership, while agency to sell, this delivery does not transfer ownership. In sale, the buyer has the obligation to pay the price, but in agency to sell, well, the agent is not obliged to pay the price once it is delivered. In sale, the buyer has control over the disposal of the thing sold, or even to the terms. But in agency to sell, the seller remains to be in control over the disposal of the thing sold. So, when is the agent liable for the payment of the price? Well, the agent is only liable for the payment of the price once the goods were sold to third persons. So, ownership in agency to sell, ownership, terms and conditions for the sale, and payment of the price is not in control of the agent. But in sale, well, that is already the buyer's control, right? So those are the things that we need to distinguish from the contract of sale. See you on my next video, guys, for more details of the law on contract of sale.